So in terms of correspondence, in general, detained patients should not have their mail intercepted or withheld. Sections 281 to 283 of the Act make provisions for managers of a hospital to withhold the mail of patients who are specified persons in certain circumstances. These are where a person has asked hospital managers to withhold mail addressed to them from a detained patient. This request must be made in writing, where the RMO has determined that there is a likelihood that postal packets sent by the patient may cause distress to the addressee or to any other person who's not on the staff of the hospital, or a danger to any other person, or receipt of postal packs addressed to the patient may not be in the interests of the health or safety of the patient or may cause danger to another person, and as a result recorded a reasoned opinion to this effect and made the person a specified person. As with the restrictions on telephone use, the duration of a reasoned opinion for correspondence is 6 months. However, the RMO is expected to keep the necessity for designating the person as a specified under review during this time. Section 281 of the 2003 Act lists those individual organisations that are excluded from restrictions. So a postal packet is defined by the Postal Service Act 2000 and therefore excludes any form of mail not sent or delivered by the post office or other registered carriers. Therefore, correspondence by internal mail does not fall within the scope of specified persons. Any issues arising from internal mail requires to be resolved with reference to local hospital policies. In regards to withholding and inspecting packets or packages, the effects of these parts of the Act are that hospital managers are able to inspect and open any postal packet either addressed to or sent from a specified person to determine whether it should be withheld on any of the grounds. In practice, the responsibility is often devolved to nursing staff on the ward. The reasoned opinion should be very clear about the grounds for inspecting and opening mail, particularly in those circumstances where all mail from or to an individual patient is subject to scrutiny. Note the 2003 Act states inspect and open, so that an initial check should be made on the basis that there is reasonable suspicion that a parcel may contain something potentially harmful prior to opening. It does not say open and inspect. Where mail is withheld, hospital managers are required to notify the Commission within 7 days of reasons for withholding the item and the nature of the contents. They must also notify the patient. In the case of mail sent to the patient, the person who sent the item must be informed and must ensure that the person is aware of their right to apply to the Commission to have decision to withhold the item overturned. Hospital managers are therefore required to retain a withheld item of mail and produce it, if requested to us, within 14 days of a request of that review. So in regards to safety and security, this part of the legislation is potentially the most that's open to a wide interpretation. Therefore, we consider it very important that the implementation is consistent with the principles of the Act. As mentioned, the regulations apply automatically to all patients in the state hospital and the medium secure units. That does not apply automatically to low secure or IPCU facilities. As with the other restrictions, the RMO must record a reasoned opinion with sufficient evidence to support designating the individual as a specified person in respect of safety and security. The RMO must determine that the person has sought to acquire or is likely to seek to acquire any item which is likely to be prejudicial to the health or safety of any person or to the security or good order of the hospital. As before, the duration of a reasoned opinion is 6 months. The specific interventions which are authorised have to be clearly identified. This is not a catch-all specification that authorises all permitted actions. Therefore, specification should be in respect of searching, taking samples, or the searching of visitors. That is not to say that an individual cannot be subject to one or more of the permitted interventions, but that the need for each one should be clearly evidenced in the RMO's reasoned opinion or in the care plan that covers the interventions. And I've got a huge list there of what's permitted by the legislation. I'm just going to touch on some of those, but as mentioned previously, you'll find more detail within the good practice guidance. So in terms of searching, All hospital wards should have a policy on searching patients and how and when this may be carried out. The search of specified persons and of anything that they have with them in the hospital where they are detained can only occur if the RMO is of the opinion that there would otherwise be a significant risk to the health and safety and welfare of any person or the security or good order of the hospital. B, the person has consented to the search on each occasion, and C, if the person does not consent, then the search may proceed only if the RMO decides after reassessment that it should. The search may consist of a rub-down search, which is similar to that which happens in airports and can be augmented by the use of metal detectors or other non-evasive detection equipment. Only jackets, coats and shoes can be requested to be removed. Alternatively, in very serious circumstances, a removal of clothing search may be indicated. This comprises a visual examination of external parts of the body after clothes have been removed and a visual examination of the person's open mouth. Force and use of implements to assist are not permitted, and the practice of intimate searches of other body orifices is forbidden. Clearly, such measures raise important human rights issues and can have a significant impact on an individual. It is of paramount importance that any activity of this nature is carried out with due regard to the person's dignity and privacy. It is important that searches are carried out in the presence of a witness and by an authorised person of the same sex, unless it's not practicable. The witness should also be of the same sex as the person being searched. Where a specified person refuses to consent to a search taking place, the RMO should record in the notes their reasons for deciding that a search should proceed. Clearly, there must be a very real suspicion of imminent danger, as a search without consent can only be justified under these circumstances. To do otherwise would be unlawful. Equally, to do nothing in the face of a reasonable suspicion of danger to the patient or others may be perceived as negligent should something occur which was or could be reasonably have been foreseen. Taking samples. The regulation authorises the taking from external body parts and by means of swabbing from the mouth, samples of body tissue, blood, other bodily fluid or other material, the taking of blood samples and the examination of samples. The person's consent must be sought on each occasion and the RMO must agree that the action is required. If the person refuses consent and the RMO still agrees that the taking of the sample is appropriate, it is important that no physical force can be used. The privacy and dignity of the person providing the sample should always be maintained. In relation to cameras, photographs or videos taken using cameras or mobile phones may compromise patient confidentiality and privacy. Photographs and videos should only be made with the person's permission. Were these to be posted on social media without their agreement, the individual rights may not have been protected by the NHS and may result in harm while the individual is in the ward. Wards should incorporate the issue in a hospital policy dealing with the issues of confidentiality and privacy. In terms of visitors, restrictions can be placed on visitors for sound clinical reasons. It would not be necessary for an individual to be made a specified person, even if he or she was detained. That would come under a hospital policy. So notifying the Commission. Hospital managers are, many of you might know this, but hospital managers are required to inform us of each specified person using a Res 1 form. Each review of the specified person's status occurring at the request of the person or their named person may be Res 2. Any specific restrictions in respect of the use of telephones, Res 3. Any review of specific restrictions, prohibitions in respect of access to telephones at the request of the specified person, Res 3. The annual figures in relation to the number of people subject to safety and security measures, Res 4 and 5 forms. And any implementation of restrictions in respect to correspondence is a Res 6. So, the Commission's role and specified persons, in addition to receiving notifications, of which we get tons and tons, we have a role in reviewing the restrictions or prohibitions where this has been requested by the individual concerned. The Commission has a specific power to direct hospital managers not to implement specific restrictions or prohibitions. Where we have been asked to review individual restrictions or prohibitions, we will review the relevant documentation. If necessary, we will obtain further information from the individual concerned, the RMO and other relevant staff. A report will be submitted to our Chief Exec, who will consult with colleagues at the Commission to reach a decision. The decision will then be conveyed to the hospital managers as well as to the individual concerned. And I think that's all from me.